I'm David Miller with the Probate Law Group. At the Probate Law Group, we help our clients navigate the probate process throughout the state of Texas. I would like to spend some time with you today to talk about what happens when someone passes away without a will. If someone passes away without a will, we call that dying intestate. And in that case, who controls the estate and who inherits the estate will be determined by the laws of the state of Texas. If someone passes intestate, then you will need to go through an heirship proceeding if you want to probate their estate. If you've seen our prior videos about probating a will in Texas, you'll recognize that a lot of the steps are the same. First, you'll have to initiate the probate with an application, you'll have to have a hearing, you'll have to file an inventory of assets and publish a notice to creditors. But an heirship proceeding also has some additional steps and some additional complexities. First, once you file an application in an heirship proceeding, the court will then appoint an attorney ad litem. An attorney ad litem is another attorney whose job it is to represent the interest of the unknown or undisclosed heirs. In order to do this, that attorney will actually have to do an investigation into the family tree of the decedent. They will do this through looking at marriage records, divorce records, adoption papers, and witness testimony. Once an attorney ad litem is satisfied as to who the heirs are, then you will have a hearing with the court. At this hearing, you will have to have witnesses that will testify to who the heirs are and the applicant, and those witnesses will be subject to examination and cross-examination, or otherwise questioning from the attorney ad litem, and from the judge. Once the judge is satisfied as to who the proper heirs of the estate are, and is satisfied that the applicant is qualified to serve as the administrator, then the judge will issue an order naming the heirs of the estate and the letters of administration. Sometimes heirships can go fairly smoothly, but they're always more expensive and lengthier than a traditional probate of a will. Also, an heirship gives rise to additional complexities, especially in the case where there are blended families, estranged family members, there's community and separate property issues. And for these reasons, a heirship proceeding can be much more difficult. Because of this, we always recommend that our clients get a will and store that will properly so that it can be used in the case of their death. Probating an estate without a will can be tricky, so it's very important that you work with an experienced probate attorney. An experienced attorney can help you get that estate through the probate process as quickly and as economically as possible. If you have an estate in need of probate, please contact our firm for a consultation.